to LiveOne.tv. This is another presentation of the series Law Made Easy. Today, we're here with Michael Serres, a partner in the prominent workers' compensation firm, Pyrros and Serres, LLP in Astoria, New York. We're also here together with our co-producer and attorney, George Bassias. And George, please take over.
Today, I'm very happy to be interviewing Michael Serres. Just to give you an example, Michael Serres is the individual. I also do some workers' compensation, but when I have questions about things that I don't know in workers' compensation, I'll text or I'll call Michael Serres, who I consider one of the most prominent workers' compensation attorneys in the state of New York, well respected by other lawyers in the community, well known by the judges in the workers' compensation courts. First thing I'd like to say is that to our viewers, we do not expect you to rely on the information that you're going to receive here today. This is for educational purposes. It's law made easy, the perspective of workers' compensation, and our advice to you, as always, is that if you have a real situation in a workers' compensation claim, that you seek the advice of your own attorney. We will provide you with Mr. Serres' information on this program, and you're welcome to contact him either by calling him or by emailing him. And now with the interview, Mr. Serres.
Hi, George.
Welcome.
Thank you, George. Thank you,
Yes.
Ian. Thanks for having me.
Thank you, Michael.
Appreciate it.
So Michael, the purpose of this program is to make a layperson understand how the system works. So you as an attorney, you get that phone call, somebody who is injured at work. What information do you take from the initial phone call or the initial interview to determine or not whether this person has a viable claim?
Okay. So I go through a series of very simple questions with the prospective client that calls me. Of course, after getting their name and basic information, I'll ask them simple questions like, what kind of work do you do? Give me a brief description of how you were injured. Then I'd like to know, where was their job? In other words, for jurisdictional purposes, to make sure that this is a New York workers' comp case and not, let's say, not a New Jersey workers' comp case, where did the supervision and control over the employee come from? Because that will dictate whether it's a New York comp case. For example, if somebody is based out of New York and their employer sends them to New Jersey to make a delivery or to do a repair job, for example, the fact that they got injured in New Jersey doesn't necessarily dictate that that's a New Jersey workers' comp case. It's where the person's employer is based and where they're getting supervision and control. Then I'll get into the nature of their injuries, how the accident happened, even though workers' comp doesn't matter who was at fault in causing the accident or injury, basics like that, and determining the extent of their injuries so I can assess what kind of a case it is and to know how we can assist them with their claim.
Okay. There's a saying in workers' comp, arising out of and in the course of employment. What does that mean? Okay,
so what that means, George, is that the law will look to see, was the person doing something that is work-related and for the benefit of their employer. So if a person, even if a person was making a delivery or doing a special errand, was it benefiting the employer? Was their accident work-related, or did the person take a detour and do something personal that wasn't for the benefit of their employer? That could determine whether or not it's a viable workers' compensation case and whether the accident arose out of and in the course of their job.
So if I get up in the morning and I'm rushing to get to work, I work, say, in a restaurant,
Sure.
And I get involved in a car accident before I get to my job, is that workers' compensation?
So, very good question. The general rule is that a person commuting to and from work is not covered by the New York Workers' Compensation Law. There are some exceptions to that rule. The general rule is travel to and from, unless your job requires you to start your workday the minute you get out of your bed and into your vehicle, for example. Because let's say you're a plumber and you have the company plumbing truck, and now you're starting your day by saying, okay, I've got to go to this job and that job, and you get hurt. So by and large, most cases involving commuting to and from work are not covered by New York Workers' Comp, but there are some exceptions to that rule.
Suppose my boss calls me before I leave for work and says, "Hey, George, I need a pack of cigarettes. Can you stop at the grocery store and get me a pack of cigarettes?"
Sure.
So I'm on my way to get him a pack of cigarettes, and then I get in a car accident.
Yes.
Would that be workers' comp?
So, yeah, that's a good question, and that example would be a workers' comp case because your employer sent you on what's called a special errand. So you're making a special errand, a special trip for the benefit of your employer, and that could make it a compensable claim.
Now, Michael, what if I'm an illegal alien? I'm a non-documented worker. I climbed over Donald Trump's wall and I came to New York City, and Ian here hired me to clean the building in here, but he's paying me in cash, and I've been working only for 1 day, but the agreement was he's gonna give me $1,000 a day because I'm a really good cleaner. He knows that by climbing walls, I can do a good job cleaning the walls in his building. Would that be workers' compensation?
Yeah, so we get those calls all the time, and those questions posed to us by potential clients. And the way the law is written in New York, it doesn't matter whether you're a documented worker, whether you're here in the U.S. legally, or whether you've come in, and trying to gain your citizenship. Your citizenship status does not have any impact on whether you have a viable claim. You will be covered.
How do I prove that I made $1,000 a day?
Well, that's where it gets a little tricky, because if a person's getting paid in cash and there's no proof of that, then it becomes sort of a he said type of a situation. Although in some instances we've had clients show us texts, for example, to and from their employer saying, okay, it's agreed that I'll get paid $100 a day or $200 a day, whatever the case may be. That could be brought in as evidence of how much your pre-accident earnings were going to be, or what you were going to be paid. That's important because what you can get in workers' comp checks is based on how much you were making on average before your accident.
So if I had called you, hey, Michael, it's me, George, I just climbed over the wall, and we're related. Can you give me some advice, because I'm working for Ian, he's going to be paying me in cash. Can you give me advice? What kind of record should I keep just in case I get injured?
Right. So, short of getting receipts, payment receipts, even texts to and from your employer would suffice to be able to prove what your wages were or are.
Okay. So there's different types of cases in workers' compensation. For example, if somebody came to you and they said, I injured my neck and my back, I can't work anymore because of my neck and my back, versus somebody who just came to you and said, hey, I broke my ankle or I broke my hand. Can you give us a brief explanation of the differences?
Sure, I'd be happy to explain how that works. So for reasons that I'm not even completely sure of why the law was set up this way, and New York was the first state in the country to have a workers' compensation law and system created. I'm a bit of a history buff, so I like getting into that. But to answer your question, the law as it's written in New York puts different types of injuries into basically one of two different baskets. One is injuries to head, neck, back, internal organ injuries. That's one basket. And then injuries to a person's extremities, like their arms, their hands, their legs, their knees, their feet, fingers. So for injuries to an extremity, if there's a broken bone, for example, or a strain or a bad sprain, even if that worker doesn't miss a day from work, at the end of the case, after the treatment's concluded, if there's any residual permanent dysfunction to the affected extremity, that person may be entitled to an award called a scheduled loss of use award for the injury to the extremity. For injuries to a head, neck, back, internal organ type injuries, and for those basket of injuries, a person can only get paid a percentage of their lost wages for the weeks or months that they may be out of work. And that's how that works.
Is it fair to say that if your client has an injury to an extremity, arms, legs, feet, hand, a good advice is to tell the person, go back to work as soon as you can, because whatever award you're going to get, it's going to get deducted from your final settlement.
Yeah. So again, that's a question that's sometimes posed to us in our office. And the advice that I like to give our clients is that, first of all, speak to your doctor. Determine, when it's safe for you to return to work, because different jobs have different physical requirements. So for example, you and I, we work behind a desk, so it's not that physically demanding, whereas perhaps a construction worker has much more of a physical demand. So say, check with your doctor, make sure it's safe that you can return to work, and you know your body, you know the work that's involved. But assuming that it's safe to return to work and you have an injury to an extremity, yes, the law will, in a sense, benefit you getting back to work sooner than later, because by law, at that when you get that final award for the residual damage to your extremity, the law provides a credit against that award for whatever the insurance carrier paid you while you were out of work.
I see, okay. And if it's not an extremity, if it's a head, a neck, or back, and somebody cannot return to work, what usually happens in that case?
Okay, so the life of the case is often determined by the person's medical condition and whether they're able to return to work. If usually around about approximately 2 years or more after the accident, if the person with that type of an injury or injuries cannot return to work, then the Workers' Compensation Board will seek to determine if that person is permanently disabled from their injuries, and if so, to what extent. And determining on the extent of the injury, the permanency of those injuries will dictate how much that person can receive per week for how many more years going forward, once they're classified permanently disabled.
Does that also create an opportunity for the claimant and for the claimant's attorney to do a lump sum settlement?
Okay, so yeah, another good question. So those lump sum settlements are often called Section 32 settlements in the workers' compensation system, because Section 32 of the workers' compensation law allows for final settlements of cases. However, in order for that to happen, both the claimant and the insurance company have to have a meeting of their minds. They have to have an agreement as to the amount of the settlement and the terms of the settlement. No workers' compensation judge or the board can force either side to settle out the case via a lump sum or Section 32 settlement. It's only based on, again, it takes two to tango, as they say. So both sides have to agree, and if so, the case can be lump sum or settled out if appropriate.
How, just a couple more questions, and then I'm going to pass the mic to Ian.
Sure.
How are your fees as an attorney determined in a workers' compensation case?
So an attorney's fee in New York for workers' compensation services is, first of all, it's determined by the Workers' Compensation Board. So unlike a personal injury case, for example, when you sign up, let's say your car accident case with an attorney like yourself, that there's a standard retainer form that typically calls for the attorney getting 33% or a third of whatever they could recover for their client. In the workers' compensation system, attorneys' fees are determined currently within the power of the judge and the Workers' Compensation Board. However, the universal sort of generally accepted measuring stick, if you will, is that the attorney will receive approximately 15% of the extra monies that they can get their client, above and beyond whatever the client may have received voluntarily from the carrier while they've been out of work. That's the...
But when somebody comes to see you, they don't have to pay anything,
No,
correct?
no, there's no payment up front. The client will never get a bill from the attorney handling their workers' compensation case. It is only just based on a sort of a contingency basis that the workers' comp judge will, or the board will determine.
Now, just one more question. There are scenarios, I'm sure, of individuals who get injured at work that don't want to go to a lawyer and handle the case on their own. What advice or caution would you give these people, if anything?
Sure. So again, we get those calls sometimes too, sort of saying, look, I had this, I don't want to get a lawyer because I don't want to sue my employer, for example, and I don't, and why do I even need a lawyer? So I often answer those questions as follows. First of all, in New York, you cannot sue your employer. The employer is required to have workers' compensation insurance coverage. So your claim is just vis-a-vis the workers' comp carrier that your employer is required to have. Just like if you have a car in New York, you have to have car insurance, an employer has to have workers' comp. So we're not suing the employer, we're not giving them a hard time per se. We just want to get the client their benefits, which would be medical treatment and some monetary relief for the lost time and for their injuries. So that sometimes allays some of the concerns that our clients have. The other part of it is like, well, why do I even need a lawyer apart from that? And the simple answer to that is, we in our lives we know what we know, but there are things that we don't know. So, for example, let's say a person with the injury to the extremity comes in and they have their case and they're out for 3 or 4 weeks or a couple of months. They get paid their comp checks. They think that's all I'm going to get. But they don't realize that they may be entitled to more than that. And oftentimes,
schedule award.
A scheduled loss of use award, for example.
Right.
Or sometimes the carriers with certain injuries, if the person's out for a prolonged period of time, will send the injured worker to one of the insurance company doctors. Now they're lowering their benefits, they're lowering their money, they're contesting their right to care, treatment, or surgery. And that's another prime example of how a injured worker or claimant would benefit from legal representation.
Very good. Ian?
Yeah. Could you repeat a little bit more about what a scheduled loss is?
Okay, so again, the scheduled loss of use award deals with and pertains to injuries to a person's extremities, right? So an extremity, think about it, anything apart from your central nervous system, arms, legs, hands, feet, knees, shoulders.
Yeah.
So for those types of injuries, the law builds in an assumption that at a certain point in time, the injured worker will reach a point of what's called maximum medical improvement. So for better or worse, whether they've had their therapy, whether they had their surgery, at the end of the care, there may be some residual permanent damage to the loss, to the injured extremity. When that happens, we have to get a special report from the claimant's doctor documenting what's the permanent percentage loss of use to the affected extremity. More often than not, the insurance company will have the person examined by one of their doctors that usually comes in with a lower opinion. And based on that percentage for the injured body part, the extremity, there's a value that's ascribed to it by law. And there's a formula that we use based on the percentage damage that's found to the extremity, multiplied against a percentage of the person's pre-accident wages. That comes up with the gross award. The carrier gets a credit for monies that they paid to the claimant, not the medical bills, just to the claimant directly. So for example, if a person is entitled, let's say for an injury to their wrist, to a $20,000 award at the end of their case, if the carrier, while that person was out, paid them weekly checks amounting to, let's say, $5,000 over the course of weeks or months, that gets subtracted from the $20,000 figure, gross amount. You subtract the 5, that person would be entitled to an additional $15,000 on top of their lost wages.
So there are already the scheduled losses that are already sort of prescribed. Are they estimates or approximations of?
Yes, so I'll give you an example. So for, let's say, a shoulder injury.
Yeah.
The law says that a 100% loss of use, permanent damage to a shoulder, that's, let's say, completely not usable, it's a frozen shoulder, for example, completely frozen, that 100% is equal to 312 weeks of benefits. You take the 312 weeks, if it's 100%, if it's less than 100%, if it's 50%, you take half of the 312 weeks. And then you take that percentage or that number, and then you multiply it against a percentage of the person's pre-accident wages. So this kind of gets back to George's example. Like, most people wouldn't know how to even figure that out. Let alone dealing with the insurance company who isn't going to voluntarily give you that money and is going to try to whittle it down based on what their doctor's going to say, which they pay for. They're getting their own so-called independent medical examination by one of their paid doctors to usually come in with a lower percentage.
Yeah.
So the audience understands, sometimes it could be significant. you could be entitled to another $50,000, $75,000, $100,000 that you'll never know about unless if you call somebody
true.
like Michael Serres to represent you.
I get that all the time.
Yeah.
People say, I had no idea that I may be entitled to this. And I tell clients, I say, look, even if it's a much lower amount,
Right.
you may be entitled to it. So
And
why
the
not get
carrier is not gonna tell you. The
No, they're
insurance
not.
company's not gonna tell you.
No.
They don't wanna pay it.
it? No, it has to be pursued.
Yeah.
So is it the attorney who would recommend an independent medical exam, sometimes referred to as an IME? Would it be the attorney?
It would not be, since I represent predominantly injured workers, claimants,
Yeah.
it wouldn't be, I wouldn't be sending the person to a so-called IME. It would be the insurance company that does that. What we would do is we'd say, okay, you've been treating with Dr. Smith for the last few months or year. Go back to Dr. Smith with this special form that the Workers' Comp Board wants the doctor to fill out. Have Dr. Smith put down his opinion as to what's the permanent damage that you're left with, let's say to your arm in this case. We get that report, we file it with the Workers' Comp Board, then there's usually a hearing. The carrier will want to get the injured worker examined by one of their doctors, the so-called IME, independent medical examiner, and then we compare the reports and either try to work something out, or if we have to litigate it, we take testimony of the doctors.
So when the person is injured, and assuming they've gone to the hospital at that time, they will get the first doctor's report.
Correct.
I see.
So we'll get the first doctor's report from the hospital, but then usually we will advise our clients to follow up with another doctor or doctors that can properly treat the injury, because usually in hospitals you get what's called triage, just immediate care. It's not necessarily the most in-depth care. And then we'll say, make sure that that doctor accepts and knows how to handle a workers' compensation case, because although we want to make sure that the doctor is a really good doctor, but also knows how to navigate through the medical forms and things that they are required to submit to allow us to have a viable case, because that's evidence that we need. And if it's not in the proper form that the Workers' Comp Board wants to see, it's almost like it doesn't exist.
Let me ask you this. So the carrier, and we're talking the insurance company, requests that the claimant go for an independent medical examination. Would you advise the claimant to take a friend or family member with them for that examination?
Sure, that's a really good question, Ian. So first of all, I just want to say that by law, the insurance carrier does have the right to have the injured worker, the person, examined by one of their doctors. I call them so-called independent medical examiners because they're not independent. They're paid by the insurance company.
Right.
So they're really medical consultants for the insurance carriers. And then by law, under provisions of the Workers' Compensation law, the injured worker does have the right to have somebody come with them and to have that examination recorded. And we typically will just advise the client, either bring a friend to do it, or you can even do it with yourself, by yourself. Take out your phone, record the examination.
Right.
Because we've often seen instances where insurance company doctor will say, well, I spent 30 minutes or an hour examining the person, and our clients come back and say, it was a 5-minute exam. Like the person didn't even ask me to disrobe. So we say, let's get it recorded. Let's make sure that it's consistent with what the report is going to say.
Related to that, what happens if the independent medical evaluation, or the doctor or the consultant doctor says your client is fine, contrary to the original doctor's report?
Yeah, so if we get, and that does happen, unfortunately, on a fairly regular basis, where, again, after a course of time or treatment, after the initial accident, excuse me, the insurance company will have the person examined by one of their doctors. And usually their doctors are going to come back and say something like, well, this person is maybe disabled, but maybe at a far lower level than what the injured worker's doctor is reporting. Or saying that the person is not disabled at all, whereas the injured worker's doctor saying he or she really is disabled.
Yeah.
So now you have a situation where there's a big discrepancy in the medical opinions of the two doctors, or or the claimant's doctor or doctors versus the insurance company's medical consultant.
Right.
When you have a vast difference of opinion and we can't work out a resolution with the insurance company to make sure the person can continue to get paid at a fair rate, if there's a logjam and we can't, there's no meeting of the minds to get that resolved, then the judge, the Workers' Comp Board, will will direct that we take the deposition testimony of the insurance company's doctor and of the claimant's treating doctor or doctors. They'll testify about their respective opinions based on examination, based on the diagnostic test results like MRIs or X-rays, and then it goes back to the judge to make the decision about the level of the person's disability, which will impact the rate of pay that they can receive on a weekly basis.
To resolve it, it requires expert witness testimony then
Yes,
from the
yes.
two parties.
And taking medical testimony, an attorney doesn't, to do this kind of work, an experienced attorney needs to not only know the workers' compensation law, as you know, George, but also needs to know enough about medicine to know what type of questions to ask the doctors. So that's another example where most lay people don't, have that in their tool belt, because why would they?
Or
Having the
even some
knowledge.
attorneys, maybe.
Yeah, a lot of attorneys. So we, in our practice, Ian, a good amount of the work that we receive or clients that get referred to us are from other attorneys, because they know enough to say, look, let's send this injured person, this injured worker, to an experienced workers' comp firm that knows the ins and outs and knows how to take depositions and the forms, and it's a labyrinth that needs
Yeah.
to be navigated.
Yes. George, did you have something?
In light of COVID, a lot of things have changed in the court system.
Sure.
But could you tell the audience, and correct me if I'm wrong, it seems like the New York State Workers' Compensation Board is way ahead of many of the other courts, like the state courts, the Supreme Court, the civil courts, with online hearings. They were already set up for
Yes.
it years before COVID
Yeah.
hit us.
Yeah, it was really forward-thinking or fortuitous on the Workers' Compensation Board's behalf to set up a system even before we had the pandemic and before COVID and we couldn't leave our houses and courts were shut down, where a system had been created where we can still have hearings where the judges, everybody knows the term Zoom, but it's not exactly through the Zoom platform, but it's a similar platform that the Workers' Comp Board set up that's secure, where the injured worker, the claimant, could appear remotely, either through their camera, the phone, or their computer, or even by telephone. And the attorneys will appear in their respective offices or homes, back when we couldn't even leave our homes. And then you'd have the judge behind the camera and having their own computer screen to preside over the proceedings. So that existed even before the pandemic hit. It wasn't used to the extent that it's being used now after the pandemic hit, but it was there, so it was in place. And then as soon as things got a little crazy in the world with the pandemic, we were able to continue to represent our clients. Claimants could have their hearings, and the issues could be addressed in a timely fashion. So yeah, you're absolutely right about that, George.
Michael, could you tell us, I wasn't aware, is there a separate branch of the court systems just for workers' compensation?
Yeah, absolutely. So when the workers' compensation law was created over 100 years ago, it set up a separate tribunal, if you will, a separate court system. They called it, the umbrella is called the New York State Workers' Compensation Board. And that workers' compensation court, or board, if you will preside and will come up with rules regarding medical examinations and the forms that need to be used and how hearings are conducted, and will, the judges within the system will make the decisions when there's when necessary, when there's, let's say, a difference of opinion on medical issues, or just formally getting the case established for the person's injuries. So it's its own court system unto itself.
Because people are injured and it's as serious as a physical injury, do those courts move a little faster than the other courts?
Well, yes. The short answer to that question is yes. A typical negligence case, before it can really get a trial, could be years often. Before that, maybe there's some motions, but to get a decision, it's often measured in years. Whereas in the workers' compensation case, it's often months before a hearing can take place. So, when a case is being contested, for example, you're not waiting years before you get a decision. For an injured worker, even months is a long time, and that we can all appreciate that. If you're injured, you're staying home, you're not getting the treatment you need, or not getting, you can't pay your bills. Weeks or months can feel like an eternity, but as compared to other types of courts, it's a far shorter duration that a person has to wait to get their justice.
Right. That's probably reassuring.
Yeah, for sure.
So
Sure.
oftentimes, Michael, when somebody comes to you with a claim for workers' compensation injury, there are situations where there's also a third party. What do you do in terms of evaluating a case to determine whether or not there's a third party?
So any person that presents to our office with a case, part of the evaluation that we do, that was one of your first questions, is we ask about the facts. We try to delve into the facts of how the person was injured. Now, as we said before, you cannot sue your employer. The employer, is insulated, protected by the workers' compensation law. They have to have workers' comp insurance. The idea is you can't sue your employer, but you can get your workers' comp benefits against vis-a-vis your employer, even if the employer was at fault for giving you a bad ladder, or the truck that they gave you malfunctioned. But in some cases, there may be what we call a third-party action, or a negligence case. We call it a third-party action because it may be a claim or a cause of action against a party other than your employer. That would be the third party. So that is very fact-specific. So I'll give you an easy example. Let's say a person, their job is to deliver packages for a living, whether for UPS, FedEx, or some other delivery service. And they're driving their vehicle to make the delivery, and unfortunately they are involved in a motor vehicle accident that they did not cause, they were not at fault for. So that person would have two cases. One is the workers' compensation case, because they got hurt in the course of performing their job. And the other case or cause of action would be a lawsuit against the other motorists that caused the accident and the injuries. So in that case, although there's one accident, it has spawned or created two claims, the workers' comp case and the personal injury case.
And if the person's totally disabled, they might be entitled to Social Security disability.
Yes.
So you have three cases.
On top of that, yeah, so Social Security is a federal government system where the federal government will look at factors including a person's injuries. They'll look at illnesses, even if they're non-work related. It could be diabetes, high blood pressure. They'll look at the totality of a person's injury or illnesses, and then determine if that person is entitled to receive Social Security disability benefits, which also factors in how many years they worked and paid taxes into the system.
Got it. What happens if the employer has no insurance?
If they don't have workers' comp insurance,
Yes.
I mean? So that person would still have a workers' compensation case vis-a-vis the uninsured employer. So what would happen in cases like that is that the uninsured employer broke the law by not having workers' comp insurance. So now they're brought into the case. The company and the individual owners of the company will now become personally liable for that claim. If they don't pay, which they often don't, unfortunately, then the state of New York, through something called the Uninsured Employers Fund, will step in, and after the case is established and the person is determined to be entitled to awards. The state will pay the injured worker the benefits that they're entitled to, pay for the medical bills also, and then they can pursue getting recovery from whatever was paid out against the individual owners of the company.
Very interesting. This is why you have to call Mr. Serres if you have a workers' compensation.
I just thought we should
Appreciate
get a telephone number put right on the screen and
Yeah.
take the calls
Sure,
in
and
live.
I'm happy to take calls from, anybody from your viewers,
Yes.
and be happy to answer questions as they come up. So, yeah, appreciate that.
Michael, if I could, this is Law Made Easy, but I think that something called the Section 32 agreement plays a part in many workers' compensation cases. What is the Section 32?
Okay, so, yeah, I touched on that a little bit when I was answering one of George's questions, but the Section 32 agreement, the reason that it's called a Section 32 settlement agreement is that Section 32 of the Workers' Compensation Law allows for full and final settlements of claims. That's where the claimant and the insurance company will have to have a meeting of the minds to say, okay, let's settle this case for X amount. It only happens if both sides are willing to agree. If one side is not willing to agree, for example, carrier's not willing to pay enough, for example, to settle the case, or the claimant doesn't want to settle the case for whatever reason that they may have, and there are some valid reasons for not maybe wanting to settle the case, then you don't have the agreement, and there's nothing to be ruled on. The judge can't force that type of an agreement, and what happens is to finalize it, there's a series of documents that have to be prepared, the parties have to sign it. After they're fully signed, they get submitted to the Workers' Comp Board, and then there'll be a final hearing for the judge to approve the agreement. And then, and only then, will the award be paid out.
And when that agreement is reached, can the claimant go back to work and resume working
Yeah,
again?
absolutely. After the case, for any case like that, where it's closed or settled on a Section 32 settlement, at that point in time, quite frankly, nobody will care. The carrier doesn't care what the claimant does or doesn't do with their money or their lives, for that matter, after the case is finally settled out.
So that's it. There you have it. You had one of the best, if not the best, workers' compensation lawyers for claimants in the state of New York. And again, as a disclaimer, my advice to you is if you have a workers' compensation claim, don't try to handle it yourself. Hire a lawyer that's an expert in the field. You heard Mr. Serres often gets cases from other lawyers. Not any lawyer can handle a workers' compensation case. It should be a lawyer that specializes in workers' compensation. So feel free to call Mr. Serres. Thank you for joining us today.
Well,
Have a great day.
George, Ian, thank you for having me. And again, I encourage any of your viewers, if they have any questions about workers' comp, just pick up the phone, give us a call. We'd be happy to try to help other people out.
Super. Thank you very much, Michael. Thank you, George.
Thank you,
We'll
Ian.
see everybody again on the next episode, Friends of the Court, special series, Law Made Easy.